Welcome to the Law School Toolbox podcast. Today we're talking with Jason Jones, a former law professor who's one of our Law School Toolbox tutors, and we are talking about a very important topic, which is how to use rules on your exam. So your Law School Toolbox host today is Alison Monahan, and typically I'm here with my co-host Lee Burgess. We're here to demystify the law school and early legal career experience so that you'll be the best law student and lawyer you can be. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the Catapult Career Conference. I also run the Girls Guide to Law School. If you enjoy the show, please leave a review on iTunes or your favorite app. If you have any questions, don't hesitate to reach out to us. You can always reach us via the contact form on lawschooltoolbox.com, and we would love to hear from you. With that, let's get started. Welcome back. Today we're talking with Law School Toolbox tutor and former law professor Jason Jones about a very important aspect of law school exam success, using legal rules. Now, some of you might be thinking, duh, of course I know how to use legal rules. It's all we talk about in class. I have them all in my outline. Oh, gosh, you think I'm stupid? But I have to say, we see a lot of exam answers where students absolutely swear to me that they knew the rules backwards and forwards going in, and they don't really include the rules at all. So, Jason, why do you think this happens? Where are students going wrong?
Well, thank you for having me today, Alison. I appreciate the opportunity to be on the Law School Toolbox podcast.
Oh, we're thrilled you're here. I should have said that in advance.
Thank you. I think this happens because of a couple of reasons. In my experience, I think that students struggle with, firstly, not recognizing the role and the importance of legal rules in exam writing. That's not to say that I think that students don't understand the importance of legal rules, because I think absolutely they do. It's that they don't really appreciate the role that the rule plays in their legal writing, and specifically here, their exam writing. And then secondly, I think the problem is, and I think it stems from the first one, is that the rules that they do include are typically not thorough enough to accomplish what the rule is supposed to accomplish in exam writing. So I think that, go ahead.
I want to unpack both of those because I think there's a lot of stuff going on there. So what is the rule supposed to accomplish?
So, from my perspective as a professor grading an exam, I'm looking for a couple of things with the rule statement. The first sort of initial check that I'm looking for is, does the student understand the rule and why they're using it in this particular context and to address this particular issue? Mm-hmm. And then secondly, the rule, when properly laid out and explained, will then lead to the analysis portion of the essay. And so the big struggle there is, students want to and have a desire to what I like to say, quote, answer the question.
Right. Yeah.
Which is, that's kind of how we've been trained, prior to coming to law school. And some people, their undergraduate degrees are focused entirely on just answering the question, and the thought process and all of the backstory that leads up to that answer has always been sort of irrelevant. And so what I think students struggle with from a transitional point from undergrad to law school, or from non-legal writing to legal writing, is making sure to have the rule as in there that answers the question of why am I using this rule, how does it apply to this issue, and then teeing it up then for the analysis.
Yeah, I think that's interesting. I mean, I think definitely a lot of people struggle with well, I just need the answer. Like, what's the answer? That's what they're looking for, right? I need the right answer. That's what we do as lawyers. And I think disabusing yourself of that notion is actually one of the most difficult parts of law school. Like, I remember being really frustrated because I had worked as a programmer before I went to law school. So, I was fine with like logic and all of that. But when you're a programmer, there's a right answer. Like, either it works or it doesn't work. And so you might spend a lot of time and energy getting to that point, but you get a really clear answer, which is like, yes, this code accomplishes the task it is supposed to accomplish. You can now move on with your life. But I feel like we never get that kind of closure as lawyers.
Yeah, and I think that there's sort of the famous book out there that's called Getting to Maybe, and
Right.
it's trying to remove that temptation to have that answer. In fact, I was just yesterday working with a student on the parole evidence rule, and the biggest hurdle that students have with the parole evidence rule in contracts, for example, is they don't want to commit to the notion that extrinsic evidence is now going to be a part of the contract. And
Hmm.
what I tried to say to her was, you're not saying that. What you're saying is that the court can admit the extrinsic evidence, and then it's up to the fact finder to make the determination as to whether it was part of the contract. And so it's a little less of a commitment than you think it is. And I think that taking that kind of less committal approach to legal writing is actually a successful way to write on an exam. Instead of trying to have the commitment to the answer and then having your entire sort of essay reach that conclusion that you've already predetermined, it should be less commitment to that answer and more of an exploration of what the possible outcomes could be.
Right, I think that's absolutely right. I mean, I sometimes think of it as like a ball of silly putty or something that you're kind of stretching in these different directions. And how far can you stretch an argument before it just breaks and it's clearly just not even worth discussing. But I mean, there's a lot of give in a lot of this stuff. I mean, you see this in the real world where judges come to different conclusions about the law and that kind of thing. So yeah, I think that point about not sort of deciding like, okay, Jill is going to win, and then making sure that your discussion makes sure that Jill wins. That's not really the goal of, I would say, pretty much any law school exam. Sometimes students can get confused if they're told to advocate for a certain position or whatnot. But even then, the professors really, well, you're the professor, you tell me, they're really looking for a full discussion of all the different aspects of this, right?
Yeah, and it's sort of in jumping to why Jill wins causes students frequently to skip over the important step of laying out the thorough rule. And so, again, it's sort of kind of not appreciating the role that rule plays in an exam answer or in legal writing, because they want to start off with, Jill owed a duty to the plaintiff.
Mm-hmm.
And then they jump forward with the essay and they think in their mind, like the statement of Jill owed the duty to a plaintiff is the rule statement, because it lays out that duty.
Right. So, Jason, can you give us an example of sort of when students think they're using a rule, but they're not really using a rule?
Yeah, and so, the kind of Jill owes a duty to the plaintiff, there's a little bit of kind of using the word duty that might suggest that they're using the rule, or oftentimes they'll say in contracts, for example, so-and-so made an offer to, Jill made an offer to Jack.
Right.
And the use of the word alone, because of all of that comes with the word offer, oftentimes seems sufficient.
Right.
And, or they'll say, Jill made an offer to Jack when Jill said, I'll sell you my car for $1,000.
Right. And that sounds sort of rule-ish.
It does sound sort of rule-ish. And what it does is it kind of, it shows that they know what an offer is.
Or the concept of an offer exists.
Exactly. So I know that I need an offer in order to have a contract. I know what an offer is. And here I'm showing that an offer exists because Jill promised to sell her car for $100 to Jack. And, all of that is kind of true. And that's the difficulty is, when we're talking about legal writing, we're not talking about, do you know the rules? It's how are you communicating those rules? Mm-hmm. And I think that, before I said that, students don't appreciate kind of the role and the importance of legal rules in exam writing. And I think that's really the fault of, us, myself and other professors as legal educators, because I don't think we do a good enough job explaining the necessity to unpack the rule and lay it all out there. When we say, put the rule in there and they say, there's an offer, that translation actually makes sense. But what professors are really looking for is not only that you acknowledge the need to put the rule of an offer in there, but that you actually lay out the full manifestation of the willingness to enter into a contract, et cetera, et cetera, et cetera.
Right. Well, give me the et cetera. So what would a better statement of like, okay, I recognize there's an issue here. I mean, this is first step one. You have to recognize there's an issue about, is there an offer? Is there not an offer? We can talk in a minute about how we do that. But I've recognized there's an issue. Jill needs to have made an offer. What does a decent rule statement for that look like?
Well, so the concern is that, it needs to be verbatim. And it doesn't.
Okay, so I don't have to have memorized, in order to make an offeree must do whatever, blah, blah, blah.
Yeah, so
straight out of the restatement.
If we're going with the restatement, right? So then we're talking about the offer being a manifestation of a willingness to enter into a bargain, so made as to justify another person in understanding that his assent to that bargain is invited and will conclude it, right? So that's, I think, roughly. I haven't looked at the restatement in a few months.
You lost me somewhere around like a cent. I don't know.
Yeah,
it sounds good. I don't know.
Yeah, so roughly that's the definition of an offer under the restatement, right? So obviously, if I, having taught first year contracts for 10 years, am not going to be able to roll the verbatim offer off the top, the definition for offer off the top of my head. My expectation as a professor is not, of course, to assume that the student can, right? But my expectation is that that the student understands that there's some sort of manifestation of a willingness to enter into a bargain or manifestation of a willingness to enter into a contract, and that they are inviting the assent of the offeree, right? Mm-hmm. So laying that out just with a little bit more depth shows that you understand not only that an offer is needed, but what the concept and the rule of an offer is.
Right. And what you said sort of gives people a roadmap, too, to how to do that analysis, because it's like, well, there are different pieces in that rule, right? It's not just sort of like, oh, this is one thing. It's like we can break that down and look at those pieces individually and really analyze them.
Yeah, exactly. And that really is why legal rules in legal writing are so important. I mean, before I said it kind of shows me that the student knows why they're talking about this specific issue, what the rule is going to do to address the issue, but it also lays out your analysis. I mean, in that rule itself, it gives you the things you need to talk about.
Right.
When Jill says, she says to Jack in a conversation, I will sell you my car for $100. That is the manifestation of the willingness to enter into the bargain. And then we can take a look at it and say, when Jack receives that communication, is he justified or is it reasonable for him to believe that all he has to do is say yes and a contract has been formed?
Right.
And so now you've got analysis.
Right, because you can see a fact pattern where she says, I'll sell you my car for $100. And he's like, okay, great. Or a different fact pattern where it says, I'll sell you my car for a kiss. Is that a real offer? Well, it sounds the same, but there's probably more to talk about.
Exactly. And so I think that, the role of the legal rule is to give you something to talk about when it comes to the analysis and to show that, there is a sort of a legal rule that's applied universally when discussing this particular issue, and it gives structure to the essay.
Right, and I think it can also help you sort of identify those sub issues and things that probably make the difference between the A answer and the B answer. Because if you just say, oh well, there's an offer because she said this, you're not really unpacking maybe this is a slam dunk issue and it's like, yeah, okay, she said she'd sell the car for $10,000. The value of the car is $10,000. You don't need to spend a lot of time on this. But there might be other stuff going on. And I think having, those sort of more detailed, often like element by element statements can really trigger you to think about on an exam, like, oh, is there something I need to talk about here? Or is this a slam dunk issue?
Exactly. And what you're saying with the unpacking makes sense, because the biggest issue that students are running into in this area is too many decisions are being made in their head.
Right.
And not enough of those decisions are being made on the paper.
Yes. I talked to a number of people in the last few weeks who are like, I feel like I know everything. I'm just not getting it on the paper. And ultimately, what you get down on paper is what you're going to be graded for. So
exactly. And what the tendency to put on paper is the answer to the decision. And what we're really looking for and what legal writing really asks is, what are all the questions and rules and answers that led to this ultimate decision.
Right. Because I mean, what you referenced earlier, if you say, Jill made an offer because, I think what students don't really realize is that's actually a conclusion.
Yes.
That's not a starting point.
Yeah, and exactly. And one of the things I wanted to talk about today was exactly that, the tendency to bury the rule in the conclusion statement, as opposed to breaking it out itself. So like you said, Jill, the answer would be Jill made an offer because she promised to sell her car for $100. Well, in there is some of the elements of the rule. But it's just a conclusion statement, and the rule is kind of buried inside of it.
Right. All right. Well, before we really dive into that, what are some other issues that you commonly see with regard to rules? I mean, some people just leave them out, but what do other people do?
Yeah. So the opposite of leaving them out is the rule dump, or the rule block. And that's the other tendency. The other tendency is to, when the proctor says go, to basically take everything in your outline that you've committed to memory and regurgitate it onto the page.
Right.
And then, believing that's sufficient, then you go into a standard problematic exam answer, which just becomes kind of a narrative of what's going to happen and why you think that's going to happen.
Right. Can you give us an example of that?
So, for example, I could say, as soon as the exam starts, I write out, offers a manifestation of a willingness to enter into a bargain, so man is to justify, Then
they write about acceptance, they write about consideration, they write about whatever.
Acceptance, consideration, promissory estoppel, unilateral contract offers, bilateral contract offers.
Mailbox rule, like everything.
Mailbox rule, offer termination, rejection, all that kind of stuff. Every rule is on the page, right?
Yeah.
And the entire issue is just whether there was a contract.
Yeah.
And so then they jump into, here, Jill said she would sell the car for $100. Jack said he would buy the car for $100.
And as a professor, you're thinking, well, I already wrote this out. Why are you telling me this?
Like, this is the fact pattern, right? I don't think, something like along the lines of, there obviously is a contract here.
Yeah,
Jack might also be able to
contract.
Yeah, the word clearly is always an indication. Clearly, there's a contract here. Jack could also win under promissory estoppel, as mentioned above. Therefore,
Sorry,
there's an enforceable contract. No, I mean, yeah, I read them every semester, and it's the answer to the question.
Yeah.
Is what it is, and the thought of, well, and then I sit down in the meeting and I say, okay, so here's why you scored, and the always question is, well, I put every rule in there.
You're like, great, thanks for that.
and it's true. And I was like, well, that's true. And what you've shown is that you can memorize, right? And that you have the ability to memorize rules. But, if we're looking at kind of the, Bloom's taxonomy, the sort of pyramid of learning and all of these other sorts of things, right? Knowledge is at the bottom, and application and analysis is where you start climbing that ladder. And to regurgitate the rules up front doesn't show to me that which rules apply to which situation, and that you're able to work through those rules in an application of the facts to reach the conclusion that you ultimately reached.
Right, because ultimately what you're really testing is legal judgment. And if you walked in, I was a litigator. If you walked in a courtroom and said, Your Honor, here's a bunch of rules that might or might not apply to this situation, they're going to be like, what are you doing?
Exactly. That's exactly right.
Just tell me, cut to the chase. What do I need to know here?
Exactly. We're not testing sort of the ability to memorize all of the various rules in contracts or property or torts or whatever the first year class may be. What we're testing is, do you know which rules to use, and can you do a legal analysis? And that, what you just said with the litigation example, is great, right? You're not going to walk into a court, give sort of the litany of rules of first-year contracts,
like, Your Honor,
and then at the end say, Jill has a contract.
The definition of summary judgment is blah-de-blah. The rule that governs it is civil procedure. It's just like, I know what summary judgment is. Could you please get to the point?
Exactly. And you only got to the summary judgment part after you walked through, supplemental jurisdiction and all these other non-applicable rules, just as part of kind of showing the judge that you knew all of the rules of civil procedure. And I think that legal educators don't do a good enough job of communicating the value of rules and why we're asking for them in that fashion.
Right. Well, let's talk about that. So What's really the goal here? I mean, what should students be trying to do with these rules on an exam beyond just writing them down so they can get points?
So I think the goal of using rules is to lay out the structure of your exam essay and to say, I'm going to talk about offer first. I'm going to give a thorough rule for offer. It's going to lay out the elements of an offer. Then I'm going to apply the facts to those elements and reach my conclusion. Then I'm going to jump over to the definition of an acceptance, and I'm going to lay out the rule for an acceptance. And then I'm going to go through the elements of acceptance. And then I'm going to apply the facts, and then I'm going to reach my conclusion as to whether there was an acceptance. And what you start to see as you organize it in that fashion is your essay becomes a series of RAC paragraphs.
Right.
Where
I feel like it almost makes it easier. It's like, don't overcomplicate things. Just write down the rule and apply it.
Exactly. And it's almost kind of mechanical in nature, where you're just sort of saying, I'm going to write down the rule as it applies to this issue, talk about why it applies to this issue, maybe explain the rule a little bit, and then I'm going to apply the facts, I'm going to reach a conclusion, I'm going to move on to the next thing and move on to the next thing. And so the question of sort of whether there is a contract ends up being, instead of one giant paragraph that lasts 3 pages, or maybe a rule dump that lasts 2 pages and then a conclusion, it ends up being 5 or 6 RAC paragraphs in a consecutive form that has a well organized legal analysis.
Yeah, I mean, I remember I hated contracts my first semester. I just didn't like the class. I thought I was going to do really poorly in it, and I ended up doing really well. And I think the reason for that was I actually made a flow chart that on 2 pages basically captured the entire course. And I literally had questions. It was basically like, is there an offer? Well, what are the sources we would look to? Here's what the restatement says about it. Here's what this case says about it. Is there an acceptance? Where do we look for that? And so even though I didn't feel that confident, it was an open book exam, thank goodness. But even though I didn't feel so confident with the material, it actually enabled me to do that type of very sort of structured analysis that I think paid off, in the end, against people who probably knew way more about the subject matter and were, liked it and were confident, but they were just droning on and on about things that weren't as relevant, so they weren't getting those points.
Yeah, and that's a great point. I've got an older brother who's about 10 years older than me, and I was complaining about a grade in a particular law school class to him in a phone conversation. He has an engineering degree, and he said to me, and it stuck with me for 15 years now. He said to me, he goes, sometimes the classes where the material the best are not the classes where you do the best on the exam.
Oh, for sure.
And the reason why that is, and engineering is kind of similar to law in this regard, it's a show your work sort of scenario. And sometimes the material so well and you've got the rules so memorized in your outline that you get to the exam and you're able to answer the questions easily, not kind of recognizing that the professor doesn't really care if you know the answer to the question. They want you to show your work. And part of showing your work is putting the rule up there. I use math as a frequent analogy, right? If you're going to kind of do, a squared plus b squared equals c squared, you're going to lay that formula out first, and then you're going to put the numbers in, and then you're going to work through the formula. And the rule works the same way in legal writing.
Yeah, I mean, I think being a programmer kind of helped with law school because you did have this okay, if this, then this, if this, then this, if this, then this, if not, then this, and it's very, it's not I think sometimes people really they just really overcomplicate things.
Yes. Whereas I was a business undergrad and we were told never to exceed more than 1 page and that we only cared about the conclusion. So it was kind of the opposite sort of dynamic. But yeah, I mean, the goal with rules is to lay out the showing of your work on the exam so you can show to the professor the legal analysis that got you to the conclusions.
Yeah, and I always wonder with people who say, I knew everything, I studied, I went to class, I did my outlines, I took practice tests, and then you see their answer and you're like, what happened here? I mean, do you think people just sort of panic when they get in there, or do they just not realize what they're doing? I mean, what's going on?
Well, I do think that there's there are some panic issues, some anxiety issues. Your brain kind of shuts down a little bit. Oftentimes, if it's one of the first couple of exams that you've taken, you're not yet comfortable with the experience. I remember distinctly my con law exam the first semester of law school where, I knew every single thing about, everything that I needed to know for con law. And I just had not seen a fact pattern delivered to me in that manner. Mm-hmm. And it threw me off. Same thing, civil procedure. Civil procedure was a class I got an A- in law school, and I went into the professor afterwards, and I said, why did I get an A-? I knew everything. And he says to me, he said,
let me back up. I was like, you were complaining about an A-?
Yeah, I was, right. Because, I was, a little bit competitive, and my study partner had gotten an A, and I was slightly frustrated with that. And so I said, what happened here? And he says to me, you got every single multiple choice question right, which has never happened to me in my entire career. He said, your essay was one of the worst essays I've ever read in my entire life.
So you're lucky to get the A-, basically.
Exactly. And it was totally because when the fact pattern was delivered to me, I was totally baffled by it and the way it was delivered to me in that fashion. And it was just a simple question, does the court have personal jurisdiction, or does the court have, subject matter jurisdiction? And my answer was yes.
Great. Moving on.
Yeah. Like, why am I supposed to spend an hour and a half on this? And the answer is yes. And so I think that there's some anxiety, some sort of, not seeing it, not being comfortable with it, and that sort of initial brain shutdown of, I'm just going to answer the question.
Right. Well, to me, when you tell me that, like, I was a Civ Pro TA, so when the question is there personal jurisdiction, I immediately basically go to the attack plan that's in my head of like, okay, yes, we need to look at international shoe. Is there this? Is there general jurisdiction? Is there specific jurisdiction? Like, is this a corporation? Is it a person? Like, where are they based? Where are they domiciled? So I have that entire flow chart basically in my brain. So if you asked me that question, I would basically be like, okay, start calculating the if this. And I think that's what sometimes people don't understand is like, you don't have to know, it's not just that you need to know the law. You have to be prepared to apply that law in a structured, logical way that hopefully you've thought about before you get the is there personal jurisdiction question. Because I guarantee you, if you're taking Civ Pro, that's probably going to be on your exam.
Yeah, exactly.
Like, if you don't have a sort of framework for doing that analysis before the exam, I can pretty much guarantee you it's not going to go well.
Yeah, and so that's one of the communication barriers I was talking about with legal educators to students is we say you have to know the rules, and so the students spend all of their time just memorizing the rules, and we don't say
international shoe says, like,
yes,
worldwide Volkswagen says, it's like
exactly, and then you get to a fact pattern and it's just laying out this crazy scenario, and you're like, well, where do my rules go? And so, because there's not an obvious place for your rules, you just kind of abandon them and go to the answer to the question.
You're going to go with like your gut. I think a lot of people are like, I have a sense that like probably this person there would be jurisdiction or not. It's like, we don't really care about your sense until you
exactly
until you can until you can back that up.
Exactly. And I think it's about students understanding that rules are part of the process, or like you use the word attack plan, right? What you should be studying for when you're studying the rules is how they fit within a process that you're going to apply to an essay, whether that process is an attack plan or a flow chart or whatever the case may be. It's understanding the rules and how they fit into that. And what ultimately comes from that is more thorough rule statements, because you know that if you see personal jurisdiction, or if you see offer, or if you see negligence, right, that there is a formula that you're going to apply, and it's going to include all of these rule elements, and you're going to work through them to get to the ultimate answer.
Yeah, and I think it was something like personal jurisdiction, like oftentimes people jump into like the case-based analysis, but then they kind of forget like there's this other element, so yeah, I think the more you can do in advance to sort of remind yourself like, oh, every time I see personal jurisdiction, I have to discuss like two different aspects of it. There's like the fairness, and then there's this other stuff. However your professor frames it, they might frame it slightly differently, but that's going to help you not forget like a whole section of the analysis.
Yes. Yeah, I agree. Totally.
And I think that's true in basically every case. Right?
Yeah.
All right. So beyond having these elements, these attack plans down, what are some other things, kind of advanced level stuff that people can do to improve their rule statements on an exam?
Well, to me, there's, what we've been talking about is kind of moving up the ladder a little bit from a lesser good grade to kind of a middle of the road type grade. And of course, there are the ways to get the A. And to me, that comes a lot from rule explanation. Are you able to explain what the rule means? Maybe explain a little bit about where it came from. Certain subjects, I think, lend themselves to a little bit more rule discussion than others. Civil procedure, which is kind of a doctrine, personal jurisdiction, which is a doctrine that's evolved over time. The more you can kind of work through that evolution and explain that out, I think is beneficial. Con law is kind of similar in this, where doctrines have developed over time through different cases.
Yeah, or sometimes you'll have like, competing rules, like crim law, maybe you have the common law versus the model penal code, things like that. Like, these are going to enrich your discussion.
Exactly. And so if you can, the professor might say, this is, apply the model penal code. And if you can cut in and say, here's why this fact is particularly important under the model penal code versus common law, rule for, murder is because the model penal code, lessened or increased the decision here. And, so if you can have that robust discussion, then absolutely you're going to elevate your answer and show the professor sort of a mastery of the subject, right? I mean, there's kind of the ability to understand it, there's the ability to apply it, and then there's the mastery level, which is being able to explain it all out.
Yeah, I do have to caution students because some of them take that to mean like, oh, great, I can just write a policy essay on a fact pattern hypo and I'll do awesome. Don't do that. This is like an add-on. Yeah. This is not like the bulk of your essay.
No, and I'm afraid to go down that path too, because the majority of the time, a student can get an A doing what we've talked about so far.
Yeah, and thorough, complete, detailed analysis is absolutely sufficient.
Yeah, if your rule is, accurate and thorough and lays out elements, and if you take all of the appropriate facts and apply them to each element of the rule to reach your conclusion, you're going to get a top-notch grade.
Yeah.
That's, the policy, the rule development over time. Like I said, certain subjects lend themselves to it more than others. Nobody, really talks about the development of the offer over time. It's just kind of, right. it's not exciting. There's nothing there. Yeah. I mean, just read the restatement. We don't really care where it came from. And so you want to caution against making that your focus. I think it's sort of like my contracts professor called it the blocking and tackling. Like, get the blocking and tackling done and you're going to be okay. You don't have to worry about something fancy on the other side.
Yeah, I mean, a lot of this is not very fancy. All right, well, we're almost out of time. Let me ask you one more question.
Sure.
So where are students going to get these rules? Like, is it okay just to go look them up in a commercial outline or maybe an old student outline? I mean, assuming you did the reading, you went to class, you participated. Can you just look them up?
Well, yes and no, right? Like, they exist out there. The restatement exists out there. The Uniform Commercial Code exists. The property rules exist. The torts rules. I mean, they all exist out there. And commercial outlines exist, and previous student outlines exist. I am, a little bit old school in this regard, where, I think the only things you need are, the materials your professor requires and your lecture notes. And then from that, you build your outline that includes your rules and your attack plans and whatnot. And I think the reason why that is, if even going back a few minutes ago when I rattled off the definition of an offer, like, that doesn't make any sense outside of the context of being able to explain it and understand it. And unless you go through the process of building your attack plan and your outline yourself, if someone just hands you that restatement of second of contracts and you're just looking at the restatement rules, yeah, you can memorize them, but you don't really know what they mean, how to unpack them, what elements are more important than others, how to apply them. So for me, the rules, it should come out of your casebook, your lecture notes, your reading notes, and the development of your outline and your attack plan. And, if you're not feeling confident about certain rules or they're not making sense, I mean, your professor will help you through that. So schedule a meeting with a professor, talk to them about the rule, ask them if you're approaching it the right way. And that will do you more value than just picking up a commercial outline and flipping through it and being able to regurgitate what an offer is.
Yeah, I sometimes say it's the difference between reading a book and writing a book. Anyone can read a book, but writing a book's really hard. I mean, I kind of take a hybrid approach. I'm fine with people using commercial supplements. I think it can help, sort of clarify what you're learning. But absolutely, you can't just think that you're going to sit down and read that, and that's going to be your total, you're good to go. Like, you can use that to sort of clarify and help you figure out the structure, the big picture, the details, but you have to really make that material your own one way or another, or you're just not going to have the depth of knowledge you need to really use that on an exam.
Analogy, in education, we say it's the difference between passive learning and active learning. Passive is just grabbing a commercial outline and memorizing it and going into the exam. Active learning, building your own. And if you use supplements, and I'm not knocking, I don't mean to, knock supplements necessarily, because, like you said, if they are supplemental to the development of your outline and attack plan and your materials, then they are great. But they are meant to be supplemental materials and not primary materials. And I think oftentimes students kind of fall victim to the attractiveness as these books as primary materials.
Like, oh, they just have the answer. We're good to go. All right.
Exactly.
Well, unfortunately, we are out of time. Thank you, Jason. I think that hopefully was very enlightening for people.
Thank you for having me.
Oh, my pleasure. If you enjoyed this episode of the Law School Toolbox podcast, please take a second to leave a review and rating on iTunes or your favorite podcast app. We would really appreciate it. And be sure to subscribe so you don't miss anything. We typically release new episodes on Monday. If you have any questions or comments, please don't hesitate to reach out. You can find me at Alison@lawschooltoolbox.com, or you can always contact us via our website contact form at lawschooltoolbox.com. Thanks for listening. We'll talk soon.